All right, I will call the Board of Adjustments and Appeal meeting to order. Ms. Warwick, could you please take the roll?
Mr. Rieger,
Present.
Ms. Schmitz,
Here.
Mr. Friesen,
Present.
Mr. Thompson,
Present.
Mr. Taylor,
Present.
Mr. Collins,
Present.
Chair Finn.
Present. Perfect. I need a motion for approval of minutes from October 11th, 2023. If I could get a motion and a second.
I'll move to approve the minutes for October 11th, 2023.
I second.
All right, we'll do a voice vote. All in favor say aye.
Aye.
Any opposed? All right, no opposed. Approval of minutes passed. Approval of finding of fact from VAR 2023-010 for 4477 South Pennsylvania Street. If I could get a motion in a second.
I'm moved to approve the findings of fact for VAR 2023-010.
Second.
All right, we'll do a voice vote. All in favor of approving the findings of fact, say aye.
Aye.
Any opposed? None opposed. So approval of findings of fact from VAR 2023-010 is passed. So we'll move on to the cases. The case procedure, there are 7 members present, therefore 5 affirmative votes are required to grant variance or appeal. The board is authorized to grant or deny variance by Part 3, Section 60 of the Englewood City Charter. Anyone aggrieved by a decision rendered by this board may appeal that decision to a court of record. However, such appeal must be made within 30 days of the board's decision. Any approved variance is effective at the end of the appeal period. Building permits for construction associated with approved variances will not be issued until the appeal period is ended. Building permits must be obtained and construction begun within 180 days of the variance's effective date. Procedure for the meeting is that the case will be introduced. An overview will be given by the staff. Applicant will present their request and the reasons the variance should be granted. Proponents will be given an opportunity to speak. Opponents will address the board if present, and if needed, staff will address the board again. The public hearing for case number VAR 2023-012. The property is 4225 South Inca Street. The applicant is seeking an appeal to the primary residency documentation requirements pursuant to section 5-31-3.A.2.D of the Englewood Municipal Code. Staff, if you could present.
Raise your right hand. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Eric Sampson, Planner 2 with Community Development. All right, good evening, members. So this variance appeal request, as it were, is for, so when applicants are submitting an application to get a short-term rental license, they're required to provide a number of documents that reflect that the property is their primary residence. When council had been looking at the new code, we went through the short-term rental revisions. A situation like this came up, which is why they kind of wrote a section that we'll talk about in just a second into the code, and that is that if an applicant has recently purchased the house and wants to apply for a short-term rental license, they can waive the tax. One of the documents we require is the front page of the 1040 tax return, which reflects the applicant's address as their primary residence, being that place where they're going to operate their short-term rental. Basically, that they are the primary resident of the property they want a short-term rental. So other requirements. So we require proof of residency and ownership affidavit. The first page of the most recent filed U.S. individual tax return, which does show the address, which we talked about. And then at least two of the following is required: a valid motor vehicle registration, driver's license, a Colorado identification card, or voter registration. Those are just any of the other documents we use to confirm primary residency. So again, it was written in section 5-31-3A2D, which states documents required by subsections B and C above, which we kind of just went over, may be waived if the owner establishes compliance is legally impossible and appeal to the Board of Adjustment and Appeals. So in this case, the applicant has provided all other documentation required to be granted a short-term rental license, except for the 1040 tax return. In lieu of that, the applicant did provide documents, closing documents from their purchase of the property in July to demonstrate ownership in lieu of the 1040 tax return. So considering that information and that criteria, staff does recommend approval of this appeal. And just as a stipulation, which is also kind of built into the regulations, once their application expires next year, is about to expire, when they reapply, we require applicants to provide their latest copy of the 1040 on an annual basis. So if they're unable to produce the 1040 showing their address as 4225 South Inca next year, when they're renewing their license, it would not be approved.
All right. Any questions for staff at this time? I think we're done with you for the time being.
Okay.
Thank you, sir.
Yeah.
If the applicant could come forward to testify in the case, and if you could please state your name and address to the secretary who will administer the oath.
Raise your right hand, please.
Yeah.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Jacob Carter, 4225 South Inca Street, Inglewood, Colorado, 80110.
Thank you.
Hi, Mr. Carter. Good evening. We have your packet, everything that was submitted. Is there anything else you'd like to add to it?
I believe we had sent, is that packet the secondary information that we had sent to Mr. Eric over there?
It is, yes. It's all the information.
Then that's all we have,
Okay.
Mr. Fenn.
Are there any questions from the board for the applicant at this time?
Yeah, just to get sort of the basis of this. So you filed a federal tax return, income tax return last year?
I did. I lived
And-
in Boulder, Colorado,
Okay.
where I went to school, and recently moved down here when I bought the house in July, given that July is after the tax date.
Got it.
The tax
And you-
wasn't on there.
You're not able to file a 2023 tax return yet, correct?
Correct. And we changed the address with the IRS too, prior to applying.
Okay. And is it your co-owner who's with you?
It is.
Okay,
She's
and it-
actually been helping out with a lot of it. So
I think if she wants to talk, she can, but she'd be sworn in too. Okay.
I just need some help.
That's all I got.
Any other questions for the applicant from the board at this time? CU grad?
Masters, yeah, kind of.
I won't ask you anything about Coach Prom. So
I don't like him.
We'll just keep going. I think that's all the questions we have for you at this time. If we
All right.
need to
Thank you,
follow
Mr.
up, we'll
Fenn.
call you back. Thank you. Are there any people present who wish to speak in favor of this request? All right, any persons present who wish to speak in opposition of this request? Staff, any additional comments? Board, do we have any additional questions for staff? All right. Is there, the public hearing's now closed. Is there a motion and a second?
I'll move to approve case VAR VAR2023-012 as written.
Second.
All right. I'm looking to see as written. Are we covered with that?
Are you asking Shelley?
Do what?
Were you asking Shelley?
I think, yeah, are we covered with as written for the motion? All right, perfect. Discussion.
There's not a lot of criteria for us to consider, like legally impossible. You can't file a tax return if you've only moved there in July.
Well, yeah, I mean, I think this is a pretty, I like that everything's laid out. So it's kind of just breadcrumbs for us at this point, I think. So, yeah.
Seems pretty straightforward, especially when the renewal comes up that can't do it again without, so.
Yep, I agree.
Well, and it again, just the huge amounts, I guess, of backup information as from Arapahoe County, even via vehicular registration. I mean, it goes to the gentleman's, he purchased his house at this time and that's his primary residence.
Yep, I agree. I think, yeah.
Unless you want to buy a car to prove that you, but
Any other discussion or should we just vote on this? All right, let's vote. This work?
Mr. Thompson,
approve.
Mr. Rieger,
I voted approved.
Ms. Schmitz,
I vote to approve.
Mr. Friesen,
I vote to approve.
Mr. Taylor,
Vote to approve.
Mr. Collins,
Vote to approve.
Chair Finn,
I vote to approve.
motion passes 7-0.
All right, welcome to Englewood, Mr. Carter. All right, so we will move on to the next case. A public hearing for case number VAR2023-013 for 4335 South Fox Street. The request is a variance to construct a temporary metal carport in front of the primary residence, which will also encroach in the 25-foot setback. This is a variance to section 16-5-3, table 5-2, and table 5-3, and section 16-5-3.b.1 of the Englewood Municipal Code. I do have for this, I do have verification of the publication and posting, which I will pass down. And I just need to make sure I get that back because I need to give that back to Ms. Warwick. Staff, if you could give an overview. Mr. Sampson, I think we're ready for you.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Eric Sampson, Planner 2, it's Community Development. Okay, so this variance request is for a temporary metal carport, 200 square feet. Basically, the applicant is requesting this carport to protect his work vehicle from winter weather and spring hailstorms. He is planning to develop his backyard the next year to put in a driveway and a parking pad where then he will relocate the temporary carport into the back. So in terms of code, here's a little overview of what this would look like and kind of the layout of the property. So you see the driveway accesses the front of the property off of Fox Street. And code does not allow for somebody to just pull in onto their backyard and park on an unimproved piece of land. It would need to be at least a parking pad or some sort of gravel. So that situation does not currently exist at this property. And so the code that this is kind of in conflict with would be table 5.3 for minor structures. And that is the requirement that the structure must be behind the rear building line of the principal structure. So being in front of the residence, again, that would not be in compliance with code. The second one is the front 25-foot setback. And structures are not allowed to encroach into the 25-foot setback and due to the location of the house on the property and the size of the carport, you would be encroaching a little bit into that front 25 feet. So it's kind of like a twofold variance in that manner. To go through the variance criteria, unique physical conditions exist, such as size, shape, location, etc. And that's kind of what we talked about. The existing driveway currently accesses the property off South Fox Street. And the back of the property is currently fenced in and again is unimproved and doesn't have a parking pad or a driveway or any ability to park a vehicle behind the main primary structure. Oops. Ahead of myself. Okay, so the second criteria is that the condition creates a practical difficulty or a necessary hardship. And all properties are allowed to have a garage or carport to protect their vehicles. While the location of the existing driveway presents a challenge in placing a carport that meets code requirements currently, the applicant's intent to develop the rear of the property in a manner that does meet code requirements should be considered. The third criteria is that it is consistent with the intent of the zone district regulations and to secure public health, safety, and welfare. And so due to the temporary nature of this request, staff does not believe that this will adversely impact the intent of the R1C zoning district regulations or health, safety, or welfare of the surrounding community. The fourth criteria is that the variance will not permanently impair the use of the development or adjacent conforming properties or alter the essential character of the neighborhood. And again, due to the temporary nature of this request, staff does not believe that approving the variance will have any adverse impact on adjacent properties or alter the character of the surrounding neighborhood. And the fifth and final criteria is that the variance is not a self-imposed difficulty or hardship. And the variance request does not relate to any sort of action by the applicant that would make it a self-imposed hardship. So for community development recommendation, basically since the carport is temporary, staff would recommend approval with the condition that the carport be removed within 136 days of approval.
You mean 365?
What did I say?
You said 136.
Oh, yeah, 365 days of approval. So basically he could have the carport in front for a year while he works on getting the backyard developed and driveway put in and what forth. If this had been just a request for a permanent carport in front of the residence, we would not recommend approval. It's really the temporary nature of the structure, which staff feels is acceptable.
Thank you, Mr. Sampson. Board questions for staff.
Not yet.
I have a question for staff. In your view, would approving this perhaps give other people the indication that they can build carports in their front? And there might then be an increase of people building carports in their front yard without permits. And then the city having to.
Not necessarily. We enforce, and we have enforced in the past on carports that have been built in front, and in a situation like this that had been without permits, and we've gotten those removed. So,
Okay.
Yeah, I guess.
Okay. Any other questions for staff at this time? All right, thank you, Mr. Sampson. If the applicant, please come forward to testify in this case. Please state your name and address to the secretary who will administer the oath.
Raise your right hand, please. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Timothy Raymond Calvert at 4335 South Fox Street, Inglewood, Colorado 80110.
Thank you.
Hi, Mr. Calvert. Thank you for coming out tonight. We have everything that was included in the packet. Is there anything you would like to add for us to consider or touch on quickly what was submitted in the packet?
I don't think so.
Okay. And I think it was said this is your work truck that you would be.
Well, it's personal and work, but I work for myself, so.
Okay, so that would be, I guess, a work truck, yeah. Perfect, and we have the thing, any questions for the applicant from the board?
I do have one. I know on this plan, there's obviously a driveway on there. Was that driveway there prior to you building the property, or did you install that?
No, that driveway was there prior.
Okay.
What are you going to be building the carport out of? How's it constructed? So it's a prefabricated metal structure?
It's
or-
not prefab, but it comes as a kit and you put it together.
I was gonna actually ask the same question. So it sounds like something that can be put up easily and taken down easily.
Yeah, that's pretty much everything I do, so.
Would you then move it to the back or would you do something more permanent in the back?
Actually, I'm planning on moving it to the back. I'm actually planning on building a garage in the back. When
Okay.
I can get when I get the money, and there's a lot of work that needs to be done. I got to pull out a lot of concrete. So
Oh, that's
they
fine.
put posts in and it's concrete everywhere. I couldn't believe it. So
Yeah, that sounds like a good time.
For somebody.
Yeah, I'm not looking for any help to give you, but yeah, I've done that and I don't relish it. Any other questions for the applicant at this time?
Just the one other one I have is, will you be planning on encroaching the side setback at all, or just the front setback?
I don't know. I was the plan. I believe I
I
had.
think it says 4 feet, but I didn't know with it being a
Yeah.
prefab,
it-
will it extend it all over that 10 foot of the existing driveway? Because if it goes more than a foot over, it'd be encroaching on a side setback as well.
Yeah, it's actually going to be, I actually reduced the size. It was going to be a 12 by 20. And then that required a permit. I made the decision to bring it down to 10 by 20 and it perfectly lines up with the concrete. So, and I drill in and to anchor it and all that. So.
Okay.
Any other questions for the applicant at this time? All right, Mr. Calvert, thank you. I think we're done with you for the time being.
Thank you for your time.
Are there any people present who wish to speak in favor of this request? All right, are there any persons present who wish to speak in opposition of this request? All right, if you could come forward, state your name and address and get sworn in.
Cian Dickerson, District 1.
Can you raise your right hand, please? Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Thank you.
Yes, ma'am.
The agenda states that this is a variance to section 16-5-3, table 5.2 and table 5.3, and 16-5-3B1 of the EMC. Code section 16-5-3 does not seem to have a B1 and is titled Adaptive Reuse of Designated Historical Buildings. How can this carport proposal be a variance to 16-5-3 and 16-5-3B1? 16-5-5, the last page, does allow permits for temporary use and references 16-5-5, which states a temporary permit can be issued for a prefab structure if it is for expansion or replacement of an existing structure. The property does not have a carport or a garage, so it does not appear that 16-5-5 applies or that a variance can be sought based on 16-5-3 as it's specifically for historic buildings. This variance does not appear to have any published justification in code at this time. But is it even law at this time? UDC revisions became law on October 26th, and I have not been able to find, having just been presented with this information tonight, that there is anything in the new UDC that allows a variance to be justified. The temporary prefab carport, as staff says, the prefab structure size does not require a permit. So why is this before the board for a temporary permit when there does not appear to be any necessity to locate it within the required 25-foot front setback? The temporary prefab carport does not require a slab or a permit, so this could be located in the backyard with alley access and with only minimal fence removal. The justification is stated to protect a truck from hail and theft, and the hardship of moving or replacing the fence and pouring a slab does seem to be a personal problem and self-imposed hardship. And it could be placed in the backyard without going through all of this variance. And just for a note, since he only identified the weather being hail being a problem for him, the earliest start for the hail season is May 18th, and the latest occurrence is mid-August. Hail weather is not even a consideration for 4.5 months. I don't think it's ready for a variance application at this time and should be postponed until the UDC that is currently law and became law on October 26th, unless there was some provision that I don't know about. And since I was just handed this tonight, that's the law we need to be considering, not 16-5-3, which does not apply in this circumstance.
Thank you, ma'am. Any other people that wish to speak in opposition? Staff. If you could join us quickly. So the new code that went into effect when?
October 27th.
And that's online, correct?
Yes.
Okay.
Where online is that one right now?
It's on the Inglewood website on the community development page under Code Next.
Okay, so the old, just as a note, the old, what is that one? Library Muni Code website still has the old version, just an FYI.
Okay.
Can I provide a comment too? Do I need to be sworn in?
You
Yeah,
do.
please.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Brian Isom, Planning Manager. So when something gets passed through law, through our council, it doesn't immediately get codified into our Muni Code. There's generally a list of ordinances on that very first page that say these are things that are waiting to be codified. Code Next or Title 16 is one of those. I can't tell you, this is off topic, but we just had a new supplement that went in that had the short-term rental regulations that were passed, I believe, in April, and it took this long to get those put in there. So it does take some time. But the references in the staff communication and everything are referencing the product of Code Next or the revised UDC.
Thank you. And staff, you feel like this is the proper path to have this temporary carport put in, is to have this variance granted?
Yeah, I do. And just from experience, when I used to work in Clear Creek County, was my place before Englewood, it was a really common variance request. Although of course, Clear Creek has a little bit longer, a little bit harsher winters, but it was not uncommon to see these go through the Board of Adjustment.
Okay. Any other questions for staff at this time? All right, Mr. Sampson, I think we're done with you again. Or do we have any additional questions for the applicant?
I do have one additional question for the applicant.
Oh, this,
Sorry.
Calvert, if you could come on down, and you're still under oath.
So with this being a 1-year adjustment, are you you are willing to remove the carport after that 1 year, regardless of whether or not you've had a chance to make those additions to the rear? Okay.
I'll actually have it back ready.
Okay. Perfect. Thank you.
All right. Any other questions? Do we want to have any other questions for staff or the applicant? Or we? All right, the public hearing is now closed. I need a motion and a second for discussion.
I'll move to approve case VAR 2023-013, which is a variance to construct a temporary metal carport in front of the primary residence at 4335 South Fox Street, which will encroach into the front 25-foot setback. This is a variance to section 16-5-3, table 5-2 and 5-3, and section 16-5-3, B1 of the Englewood Municipal Code.
Second.
All right, discussion.
I'll go first. I think based off the first criteria, the unique condition, I think looking at the house layout itself, there isn't a way to use the current front access to put a carport anywhere behind. As well, that driveway was already existing prior to him owning the property. And therefore, without significant changes to the rear of the house, there's no way to easily add the carport today. On the second condition of being practical difficulty or unnecessary hardship, I think to do a major change to the back of his house on the fly, just to be able to park the vehicle, especially when he's intending on making a more well thought out change, would make that an unnecessary hardship to force that in the short term. Consistent with the intent of the zone district, I think his intent is to add a garage to the property, which is an improvement of the property. And I think the general intent of all zones within Englewood is general improvement. Fourth criterion around permanently impaired, I think he already spoke to the fact that it is a easily take down, put back up. So there really isn't any permanent impairment that would come in to play. And then the fifth of being not self-imposed, the front access was already there when he bought the property. Therefore, it wasn't imposed. And just on a side note, I think we need to consider the law as is, not necessarily what's published online. Since this has already been passed, it is effective.
Well, and it's published.
It's
online.
published. Yep, it's published
Yeah,
online.
just
effective,
not,
yep.
yeah, not at all. Yeah, I'm not crazy about temporary structures, but I understand the need. And I think that, I mean, it does, the criteria stands up.
I guess my biggest heartburn is really on number 3 because it's not consistent with the intent of the zone district. I think that part's pretty clear. We wouldn't approve it if it wasn't temporary. So the question really is, does temporary make it okay to be out there? And I've got a little heartburn on that one.
Yeah,
I get all the the analysis to sort of interpret the criteria to allow this. For me, I don't think it meets 1 or 4. And I'd have to read into like criteria 1 having an implied, except if it's temporary, language there, which I can't read in, but I totally understand the different perspective.
Yeah, I'm struggling with 1 also for some of the reasons you talked about, that they do seem to be conditions that can be remedied and are planned to be remedied, the physical conditions on that lot.
Yeah, I mean, I can understand the want to get the truck protected as soon as possible. And I understand the pain in the butt that it's going to be to get the back in line. I'm just not, I don't think I'm a fan of again, I think if it was consistent with the intent of the zone district, it wouldn't necessarily have to be temporary. But
Well, I just have a, as far as the definition of temporary at this point in time, could he go down to Harbor Freight and buy one and put it up without a permit? Absolutely.
right,
So where do you cross the line into Harbor Freight temporary or?
but that's where the city would, you would
step
think
in?
would knock on your door.
Right, but how, again, it would fall into the code of, hey, this is temporary.
Right.
Temporary for 2 days, 10 days, 20 days, 50 days.
But you would still need a variance for the temporary. And that's, I guess, the thing that kind of worries me is now you're gonna have a lot of people coming for temporary variances. And I mean, to me, it's, yeah. I mean, we've never had a temporary variance, I don't think. Yeah, this is an interesting one. Any other thoughts, discussion?
I mean, where I kind of land with it is that regardless, there's going to have to be major changes to the property in order to protect the vehicle. And garages, carports are something that are allowed to the majority of citizens in Inglewood, based off the access and just based off his properties. There currently isn't that rear access, and that's kind of where I drive to on that unique physical condition. Especially because to just add access isn't as easy as that, because there is additional codes that have to go along with how he adjusts the fence to make sure that the widths are wide enough and to protect it. Then we have a whole nother problem of making sure he's able to protect the rear of his house, which is why I see this as a good interim short-term solution. I mean, I think I'd also be comfortable if we wanted to consider reducing the time frame from a year. If step 1 is going to be make the back so he can put a carport in there, give him some time to do that and still be able to protect his vehicle in a way that the majority of citizens in Inglewood are able to.
I guess I'm also struggling with item 2. So I know there was an expressive, you guys have commented on item 1 and possibly 3, maybe 4 not being met, but I don't know if this is, with it being a temporary variance, I don't know if it meets the standard for an unreasonable privilege not being enjoyed, or not being him not having access, whereas other properties nearby also have the ability to put temporary structures on their properties. So I'm not sure if that's been met just by the definition of temporary.
I guess part of what I look at too is if I looked at somebody with an existing garage that was doing a major renovation on that garage, and they came to us and said, hey, in the meantime, I'd like to put a carport here so that I can do work because my car can't physically be where it is right now today. And that required us to use the front setback. That's kind of what the other way I would similarly envision this. Is the only difference here is that the garage isn't currently existing. It's where on my property can I temporarily store the vehicle in a protected state?
Sure.
Yeah, I just think then we go down the slippery slope of now there's going to be a lot of temporary. I understand believe me, I understand the need and the want. I think the solution is he has the ability to build. It's just a pain in the butt to do it. The driveway and the garage in the back. Any other discussion or should we just vote? Discussion? All right, Ms. Warwick.
Okay, Mr. Collins,
I vote in favor. Yep, I vote in favor. Based off the first criteria of unique physical conditions exist is based off the current state of both the house as well as the fencing in the back. There is only currently front access, creating a level of unique physical condition. On the second criteria, I think that there is a unnecessary hardship to make a major change in the rear of the property when there could be a temporary short-term remedy and the owner's already expressed intent to make that change to the rear, where increasing that timetable would be a bit of a difficulty. On the third, consistent with the intent of the zone district, I see it as more of a property improvement, the overall property improvement, and this being a step to get there, which I believe is part of the intent of the zone district. Fourth criterion, with not permanently impairing the use or development of adjacent conforming properties. He stated it's a temporary structure, therefore there wouldn't be any permanent impairment. And then the fifth criteria of not being self-imposed difficulty or hardship. When he bought the property, the driveway was already where it was, and there's fencing in the back. And so there really isn't a piece of that he imposed upon himself other than trying to protect his vehicle.
Mr. Thompson,
I approve for the reasons stated.
Ms. Schmitz,
I vote no. I don't believe the first criterion is met. There's lots of properties with similar setup. And I don't believe the third criterion is met. It's not consistent with the zone district, the temporary nature of it. While I totally understand the desire to do this, it isn't something that I think we can consider.
Mr. Friesen,
I vote no as well. I concur with Ms. Schmitz.
Mr. Taylor,
I vote no. I concur with the same criterion as Ms. Schmitz.
Mr. Rieger,
I voted no for the reasons stated.
Chair Finn,
Yeah, I also vote no for the reason stated. I just have a hard time getting past the first criterion, which we got to get past.
motion fails 2-5.
All right, so that is the last case of the night. Staff, your choice. Staff's choice, any of staff?
Shelley, do you have this item? I don't have anything.
I do. Angie and Tom are termed out. This probably is your last meeting, as I believe we don't have a variance case in January.
We're out.
12 years.
12 years.
Well, we on behalf of staff, we thank you for your service. This isn't always an easy board to be a part of, but we do appreciate everything that you guys do.
And I have to say my hat is off to staff because you guys, I mean, the work you do, and I know we give you a hard time from time to time. But by far, you guys are unbelievable to work with. So I've enjoyed it. Yeah, and I would do it again. Not right away, but I would do it again.
Yeah, ditto. And Shelley, thank you.
Yes,
You
Shelley.
make it all happen.
I mean, we ran off Nancy and then.
Yeah, we ran off Nancy.
All right, so since there's no case, I think this is our last one. Attorney, anything?
Nothing for me.
By the way, nice. I like the jacket and the tie, and that's very, thanks for dressing up for the board.
I got to. It's the Board of Adjustment and Appeals.
Board's choice. So, since we do not have a meeting next month, I don't know if we want to try to aim for that day to have what I'd like to have is a holiday, a going away, and just kind of a little shindig in January.
Only if she gets her confetti.
We can have confetti. So, yeah, so I don't know if I've asked about any kind of funding from the city. I don't think they've given it, but over the past several years, but
Sorry, it wasn't city funded.
yeah,
So
well, that's not surprising. But the city's had it out for me for the past 12 years over this. So anyway, I'll send out an email. Staff, you also, if you would like to come and celebrate whatever we'll celebrate. I also thought I would reach out to some of the past board members that are still around to see if they would like to join us.
And only the assistant attorney can dress like that.
I would expect,
attire.
it's, yes, it is
It's very
formal attire.
I do dress like this most of the time. Just a heads up, if we do have a get together, anyone that's not a former member of the Board of Adjustment and Appeals is open to the opens meetings law. So, well,
They're not gonna talk about any.
former members are no longer, Sunshine Act no longer applies to them. They can get together and talk all they want. But if we do get together and there's any business discussed, as long as it's 2 or more members, we do have to post an agenda, have it open to the public.
We're not gonna talk about
So
it.
can we post? an
Well,
agenda
a
that says
regular
it's free?
social gathering is not. The open meetings laws do not apply to a social gathering. No business can be discussed.
It won't be.
Yeah.
I no former wars.
Yeah.
I no former war stories.
Yeah,
Yeah. I'm fine with that
Yeah.
condition.
I would be very fine with that condition. All right. We will clear everything through you as we move forward.
Sounds good.
Perfect. Thank you, sir. All right, if we have nothing else, I'm assuming that elections will be held at the first meeting when they get, when everyone gets back with the new members on the board.
they will.
Okay, perfect. All right.
You can't keep chairing even though you're not a member anymore?
I'm just gonna come, I'm just now gonna come and be a member of the public and just speak every time. All right, thanks, guys.